Hello there, woven web enthusiasts. Today we have a District Court of Appeals of Florida case, Bates versus Bates. This is a divorce action in which the wife moved to have the court throw out the prenuptial agreement, and the court agreed. The case here is the husband's appeal of that decision. This is a summarized version of the decision, and that full decision is available online. In this marital dissolution action, Paul Bates appeals an order finding the parties' prenuptial agreement invalid because it was the product of 1, duress, and 2, coercion. On May 29, 2001, husband and wife met in Cali, Colombia through a matchmaking website called Latin Connection. At the time, husband was a divorced 41-year-old commercial airline pilot with a net worth of approximately $4 million. Husband was looking for a, quote, Christian-based woman of childbearing age, unquote, to marry, bring to the Florida Keys, and start a family. Wife, who was a virgin and had never been married, turned 18 years old just 3 days prior to meeting husband. She had the equivalent of a high school education and was in her second year of medical school in Colombia. Wife was looking for a wealthy American man to marry and bring her to the United States. The parties' courtship was far from ordinary. Because husband did not speak Spanish and wife spoke little English, they used a translator during their initial meetings. A chaperone accompanied the parties on their dates, which occurred when husband had layovers on flights to Cali. To breach the language barrier, husband used a handheld translator and translation programs on a laptop. In June 2001, during an unchaperoned trip to Cartagena, Colombia, the parties had sex and became engaged the same day. When wife later learned that she was pregnant, the husband paid for her to have an abortion in mid-August 2001, shortly before the parties were married on August 31, 2001. Wife's family was unaware of her premarital sex, pregnancy, and abortion. The prenuptial agreement and the parties' marriage. During their whirlwind courtship, husband told wife that he wanted her to sign a prenuptial agreement. Husband obtained a form prenuptial agreement from a co-pilot acquaintance and modified the agreement to his satisfaction. The parties never discussed the prenuptial agreement or negotiated any of its terms. In late August 2001, wife took the prenuptial agreement to a Colombian attorney, Alba Milan Ceballos de Lince, Attorney Ceballos, to have the agreement translated from English into Spanish. Attorney Ceballos provided wife with a Spanish translation of the prenuptial agreement. Despite the attorney signing a certification in the agreement attesting that she was knowledgeable in Florida law and had advised wife about her rights under the subject law, attorney now admits that she doesn't know Florida law and that she did nothing more than have the agreement translated into Spanish by a third party. The following day, the parties executed the English and Spanish versions of the prenuptial agreement before a notary public. The wife did not read the agreement before signing it. The next day, on August 31, 2001, the parties were married in a civil ceremony at the wife's home that was attended by a small group of family and friends, followed by a catered meal and live entertainment. Several days following the civil ceremony, the parties went to a previously scheduled appointment at the Colombian embassy to start wife's immigration process. In December 2001, the parties had a religious ceremony performed in a Catholic church in Colombia. The reason for the delay between the civil and religious ceremonies was twofold. First, as a divorced, non-denominational Christian, husband, in order to be married in the Catholic Church, needed to perform various steps to obtain approval from the Colombian Archdiocese. This process took months to accomplish. Second, not wanting to delay the immigration process, the parties had the civil ceremony first at wife's request. Thereafter, with the immigration process completed and the religious ceremony performed, wife moved to the Florida Keys to live with husband, where husband resided and owned businesses. The parties had 5 children during the course of their marriage. The petition for dissolution of marriage. In May 2017, wife filed a petition for dissolution of marriage with minor children in the Monroe County Circuit Court. Therein, the wife sought to set aside the prenuptial agreement on the grounds that it was reached under fraud, deceit, duress, coercion, and misrepresentation. Among other things, the pleading alleged that the prenuptial agreement had been executed involuntarily as a result of the timing of the agreement. The trial on the validity of the prenuptial agreement. The trial court held a bench trial on the validity of the prenuptial agreement and heard live testimony from 3 witnesses: wife, husband, and a former employee of one of husband's businesses. The parties also introduced the deposition testimony of wife, husband, and attorney Ceballos. Consistent with her deposition testimony, wife testified that she was a virgin prior to her June 2001 trip to Cartagena with husband, and that she became pregnant from having sex with husband. That husband paid for her to have an abortion in mid-August 2001, and that she was raised in a strict Catholic household that did not approve of premarital sex or abortion. Further, wife was in severe pain and distress related to the abortion both on August 29, 2001, when she retrieved the Spanish translation of the prenuptial agreement from Attorney Ceballos, and on August 30, 2001, when she executed the prenuptial agreement before a notary. According to the wife, the only reason it didn't get signed on the 29th is because I could barely walk. I was bleeding. I was bleeding and in pain. Wife further testified that when husband presented her with the English version of the prenuptial agreement in late August 2001, husband told her repeatedly that signing the prenuptial agreement was a requirement for wife to immigrate to the United States. In particular, wife testified that he told me before I had the appointment with the Colombian embassy, and in order for me to come to the United States, you have to sign this. On cross-examination, wife agreed that she would have signed anything that husband had given her to sign because wife loved and wanted to marry husband, and because wife wanted to immigrate to the United States. Coercion. The trial court essentially concluded that husband exploited the time pressure aspects of the parties' courtship and wife's vulnerable emotional position to coerce wife into signing the prenuptial agreement to husband's pecuniary advantage. Specifically, wife was still experiencing emotional and physical pain from having an abortion just 2 weeks prior, and the parties had an upcoming appointment at the Colombian embassy to start the immigration process that husband insisted could not take place unless wife signed the agreement. Based on these facts, the trial court determined that husband had engaged in coercion. The trial court found that husband's demand that the wife sign the translated prenuptial agreement the day before the wedding, or the consequence would be no wedding and no immigration, was clear coercion. Given our determination supra that the primary difference between duress and coercion is the degree of compulsion exerted by the defending spouse, we conclude that coercion, like duress, can arise where the defending spouse threatens an action for the defending spouse's own pecuniary gain. The conclusion. We conclude that there is not competent, substantial evidence to support the trial court's determination that the parties' prenuptial agreement was the product of duress. There is, however, competent, substantial evidence to support the trial court's determination that the agreement was the product of coercion. Accordingly, we affirm the order invalidating the subject prenuptial agreement.